Hello, my name is Whitney Dudley, and I'm a legal studies major here at the University of Baltimore. I'm finishing up my undergrad in the next few weeks, as it seems a lot of people are. And then I've committed about 2 weeks ago to the University of Baltimore School of Law, so I'll be hopping down there. Today, my presentation is in the form of a legal memorandum, so it's going to be a little bit different than these last couple presentations, but it was my capstone project, and the question that I was set out to answer is whether a car dealership and/or body shops owe duties to consumers, and if the car dealership or body shop can be held liable for damages that happens to a customer's car while it's in their possession. So in true legal memorandum fashion, I'm going to give you the conclusion first because attorneys like to know soon the answer and then they want to know why. So so according to my research, ultimately I did find that car dealerships and body shops do owe a duty to their consumers, and they can be held liable for damages done to consumers' property while it's in their possession if their negligence is what led to those damages. So again, just to reiterate, there's going to be two issues that I'm going to discuss. The one is going to be if they owe a duty. Two, can they be held liable? So beginning with issue number one, there was one major rule of law that pretty much summed this up, and that was the Maryland Consumer Protection Act of 1973, which requires businesses, which obviously includes body shops and dealerships, by law to meet certain ethics when participating in transactions with consumers. That was the major, statute and, that I used for issue number one. Issue number two is a little bit more involved. So I have a couple different statutes and cases that I use to support that issue. The most important thing to remember with issue number two is that there's four different elements to a negligence claim. That's duty, breach, causation, and damages. Pretty self-explanatory, but someone has to owe someone else a duty. They have to breach that duty basically by breaking the law. Breaking that law has to have been the direct cause of the damages that that consumer would have experienced. So in order to have a successful negligence claim, you have to have all four of those elements. If you're missing even one, you don't have a claim. Now, some of the statutes that I utilized here, the first one is Maryland from the Maryland Code Commercial Law, Section 13-301, which states that the use of a contract related to consumer transaction, which contains a confessed judgment clause that waives the consumer's right to assert legal defense, is unfair, abusive, and can be considered deceptive trade practice. This is obviously very important because I feel like we've all probably seen those little clauses in contracts. And if it actually went to court and the dealership or body shop pulled up that contract, the court would probably throw it out because they would think that it was unconscionable. The second statute that I have here is from Maryland Corporations and Associations Code, Section 5-121, which explains that an individual who renders professional service in the state of Maryland as an employee or on their own is liable of a negligent or wrongful act in which the individual personally participated to the same extent as the individual rendered the service as a sole practitioner. Essentially, what that means is that you can go against a business. However, if for whatever reason that business doesn't want to pay you out, you also have remedy against a particular employee if you can prove that they personally were, liable, responsible for the damages to your property. The last statute that I have here is from Maryland Corporations and Associations Code, Section 5-101, which defines a professional organization, which is a corporation organized under this subtitle for the purpose of rendering professional services. Now, the reason that I felt that this was important to put in my capstone is because you'll see in a lot of statutes, they tend to start with definitions and then they go on to say what the statute means. And this is important because it basically proves that the body shop and a dealership is a professional organization. So any statute that you see that says this applies to professional organizations, dealerships and body shops will have to hold to those statutes. Now, moving on to my cases, I have two here. My first one is Shields et al. V. Wegman. That was a case from 1988, which discussed property liability and the common area. Ultimately, what this case held is that property owners can be held liable, and even I've included this because what it supports is that if a dealership or body shop is on leased land, in the event that for whatever reason you don't have a claim directly against the body shop, you can go against that landowner if you can prove that they were negligent, i.e. some sort of lack of surveillance security that led to your damages. Now, I understand that doesn't directly support your claim with the body shop, but it is some sort of outlet of remedy. And then my second case that I have here is Miller v. Shangog, and that's a case from 1960. In that case, an employee was driving a customer's car and got into a car crash, which obviously led to damages. And in that case, that employee was actually held personally responsible because the court found that they were using the vehicle for personal use. The reason I felt that this was important to add is because if you take that principle and if the employee would have been using the vehicle for something business related, then the business therefore would have been responsible because he was acting as an agent of the business versus using the vehicle personally. So also in true legal memo fashion, I have possible arguments against the consumer. The first one is going to be that waiver of liability clause that I talked about in the beginning. I do have a case here, Adlu v. H.T. Brown Real Estate, where that was the corporation's argument that they had this clause in there that they weren't held responsible. Ultimately, the Court of Appeals did find that clauses like that are ambiguous, willful, reckless, and wanton in nature, and therefore they ruled in favor of the plaintiff because of that clause alone. My second reason here of potential arguments against the consumer would be that the body shop or dealership says that they did not act negligently because whatever happened was out of their control, which they could use. However, it would just be on the plaintiff and their attorney to really be able to prove that dealership or body shop was negligent. So as I said before, a lack of surveillance, or they left their car unlocked, something in that nature. So I hope it's okay that I'm a little early ending. So just again, in conclusion, I know I said this at the beginning, but I know the cases weren't directly with body shops and dealerships. I will say there was a lack of Maryland case law that supported that, but I believe the premise liability case, as well as the case that talks about personal responsibility of employees, kind of has principles that can be used. So overall, I did conclude that yes, body shops and car dealerships owe a duty to their consumers, and yes, they can be held liable as long as the damages was a direct cause of their negligence. Thank you.
Thank you, Whitney.
Q&A.
I have one quickly. I have a love-hate relationship with AI right now. I'm learning a lot about it, but I would imagine that one area that might be helpful for legal scholars is looking for precedent law might be something that's easily facilitated with AI. Is that your experience, or do you know anything about that?
So, and I'm not just saying this for school code reasons. I've never even touched AI or utilized it. So I'm not sure. No, and I'm being serious. So I'm not 100% sure. I've heard a little bit of conversation around it. And the problem with AI is while it's smart, that was my timer. While it's very smart when it comes to grammar and maybe knowing other basic principles of things, the problem that comes in with AI is it's not smart enough to know each and every case, especially if you're going down to Maryland. Obviously, anything that we do is going to be Maryland-based because we don't care what Arizona did. So right now, I don't think AI would be smart enough to know everything about all the previous cases. One day it might get to that point. By then, maybe I'll try and use it. Not actually, but maybe.
So from what I hear, there are currently a lot of AI programs developed by lawyers that they look specific. It's like you said, AI is very good at looking at grammar and words. So what they're looking for is specifically the difference of wording. So if there's any suspicious wording by comparing whatever's going on now to previous cases and previous ways that people say things. So that's kind of how it's used now to see if there's any suspicious thing going on. It's more likely used for general population.
Yeah, if you read enough AI writing, it has ticks, kind of like obvious ticks where it repeats stuff. Yeah, the creative writer in the back of the room is like, yes. I have one last question, and then it's Lexander's turn, I think. Do you want to be a litigator?
I'm going to tell you what I tell everybody. I don't know what I want to do yet. I'm hoping my 4 years down there is going to help me out with that. However, I've been a paralegal with car crashes, and I'm currently a paralegal in workers' comp, so I can tell you I'm not going to do those. Okay. I can tell you what I'm not going to do.
No, that explains. I was like, why pick this topic? Now I know. All right, thank you once again. Woo!